Hi friends, there are two types of alimonies. First alimony is temporary alimony and the second kind of alimony is permanent alimony. If you want to claim temporary alimony, you can claim it during the proceeding. Means once you file the application or petition for divorce, the wife can claim temporary alimony till the disposal of the divorce petition. And the second kind of alimony is permanent alimony, which is granted under section 25 of Hindu Marriage Act. In this permanent alimony, post divorce, the alimony continues till the death of the applicant, that is the wife. In India, even the husband can also claim alimony from wife depending upon the income and requirements. But normally, the alimony goes in favor of the wife considering the facts and circumstances of the case. Today I am going to talk about the permanent alimony under section 25 of Hindu Marriage Act and when the wife can make an application seeking permanent alimony under section 25 of Hindu Marriage Act. I have taken out 5 to 6 questions regarding permanent alimony and I will go through each one by one. First is whether the filing of application under section 25 during the divorce proceeding is mandatory. I mean to say, if the wife fails to apply for permanent alimony during the divorce proceeding, will she be granted permanent alimony? The answer is no. She cannot get permanent alimony if there is no application under section 25 of Hindu Marriage Act. If you want to claim it, you have to claim it within the divorce proceeding. If there is no such application within the divorce proceeding, then the court cannot grant you because there is no demand by the wife seeking permanent alimony. Permanent alimony starts once the divorce is granted or once the decree is passed. Temporary alimony ends where the decree is passed. So if you want to have permanent alimony, there has to be a separate application. If there is no separate application, you cannot go for permanent alimony in the divorce petition. So it is the first thing is that if there is no application, there is no permanent alimony. Now, whether the filing of application under section 25 during the divorce proceeding is mandatory, the answer is it is not mandatory to file the application for permanent alimony and maintenance under section 25 of Hindu Marriage Act during the pendency of main divorce proceeding. If the wife says that I don't want to file any application during the pendency of the divorce petition, she can omit. But that does not mean that her right to get permanent alimony is extinguished. The Supreme Court of India has clarified that a court can grant permanent alimony even if the application is made after the decree of divorce is passed. So if I am the wife, if I don't apply before the court seeking permanent alimony during the proceeding of divorce is going on, I will get one more option to file it post divorce. So it is not that if you fail to apply for for permanent alimony during the divorce proceeding, your right is extinguished. The divorce decree will not talk about the permanent alimony, but you can rectify that after making a separate application post divorce. So the thing is, the jurisdiction of the court to grant relief under section 25 of Hindu Marriage Act for permanent alimony is not constrained by the disposal of the main petition. If the main petition for divorce is disposed of, you can again reapply for permanent alimony in the nature of civil miscellaneous application. But there has to be an application either during the divorce proceeding or after the divorce decree is granted. You will get two options, during the divorce proceeding or after the divorce proceeding. If you even omit to file an application for permanent alimony post divorce, then this means that you don't want to have permanent alimony. So if there is an application, you will get it depending upon the circumstances. But if there is no application, then you will not get it. The application can be given inside the divorce petition during the time when the proceeding is going on, or you will get an option to file it post divorce. You have to file a separate proceeding in the nature of civil miscellaneous application, in which you can claim permanent alimony under section 25 of Hindu Marriage Act. So the answer is yes, you can file an application for permanent alimony under section 25 of Hindu Marriage Act subsequent to the divorce decree. The language of the section which states that at the time of passing any decree or at any time subsequent thereto. So you can file it during the divorce proceeding or after the end of the divorce proceeding. If you file during the divorce proceeding, then you don't have to file a separate petition. You can just move an application inside the main petition of divorce. But if the divorce is granted, if the decree is granted, then you cannot insert an application. You have to file a separate proceeding. It will be numbered. It will be numbered as civil miscellaneous application, and there you have to claim it. Then whether there is any time limit, if I don't file the application for permanent alimony within the divorce proceeding, and if I want to file it subsequently after the decree of divorce, then whether there is any time limit to file an application or a proceeding seeking permanent alimony under section 25 after divorce has been granted. The point is, there is no specific limitation period prescribing for filing an application under section 25 of Hindu Marriage Act. The phrase "at any time subsequent thereto" has been interpreted by many courts to mean that the application can be filed at any point after the decree. It may be filed within 6 months, within 1 year, within 2 years, 3 years. There is no time limit. But that does not mean that you file the application after say 5 or 10 years. You have to file it as early as possible, but there is no time limit. As said earlier, if you file it after decree of divorce has been granted, then it will be numbered separately. It will be numbered as civil miscellaneous application, not petition A, and it will be run separately, where you have to file an affidavit of income and asset, and the quantum of alimony depends upon the standard of living of the wife, the standard of living of the husband, how much are the needs of the wife, how much the wife earns, how many people are there who are dependent upon the wife, how much the husband can pay, how many people are there who are dependent upon husband. So there are multiple factors which depend while granting the relief for permanent alimony. Again, the permanent alimony starts when the decree of divorce is granted and thereafter. Permanent alimony is a different concept which is under section 25 of Hindu Marriage Act. Permanent alimony can be gotten, it can be achieved, it can be given as a relief, either as a wholesome amount, gross amount, lump sum amount, or it may be granted monthly also. It depends upon the application which is moved by the wife. The wife can say that I want to have alimony per month, then she can do so in that application and seek the relief. Or if she feels that I don't want to go for monthly alimony, I want to have permanent alimony, lump sum, wholesome, gross in a single setting, then you can also do so. So it depends upon the contents of the application. So while moving an application under section 25 of Hindu Marriage Act, be very careful and lay out proper facts and circumstances. Do not use it as a weapon. Use it as a tool to satisfy your own requirements, not as a tool for punishment. Thank you.